This is a live, is it? No. This is a recording. Okay. Recorded.
Gigi, come here a second. Bring your computer, please. I don't know, I can't see. I can't see the full page. All right, we'll start like in 1 minute. Good morning, Anna. All right, let's do this. All right. Good morning, everyone. Hang on a second, let me just do something here. It's like try to see some people, so it makes it easy, like I feel like I'm talking to somebody. My name is, for those who don't know me, my name is Giovanni Nicosia, and I am from Supreme Title and Escrow. And today we were going to do a class on the as-is contract. Okay. So on the screen, I have the latest as-is contract. Like, actually, just give me 1 second. I just want to try to do something because I don't know why I can't actually see anybody. Hang on. Let me try to figure this out real quick. 1 second. 1 second, please. All right. So basically, if you look at the contract, if you look on all the way on the bottom here, you see it says Florida Realtors Florida Bar as is 6X revised 7/23, 2023. This is the most up-to-date as is contract. It's amended every 2 years, every odd year. So it was actually just updated July 2023. Okay. There are other contracts out there, but this is what's primarily used. I would say like 95% of our deals are with this contract here. Let me just see something. Okay, so we're going to start with page 1, line 1. So if you look at the top where it says sellers, right? What's important here is to make sure you get all the sellers, the right sellers, and they all sign. Okay. So example, like one time, just 1 second, please. I just apologize. I'm a little to share something. 1 second, sorry. Gigi. Put that on mute. On mute. Okay. So one day on a Monday, I get a call from an attorney and he asks me, are you handling this file? I look it up and I am. He says, I represent the husband. How are you doing a closing on this property if the husband never signed anything, right? So I pull a file and I look at it and I see the contract's only signed by one person, the wife, right? And then I look at the property appraiser's website and it has 2 names on it. There's a husband and wife. So I call the listing agent and I say, how are you doing a closing on this property if only one person signed? He says, well, the wife told me she's getting the property in the divorce. Okay. So by her verbally stating that she's getting the property in divorce, he basically took the listing and he got a contract, right? So guess what he has? He has nothing. Like in that situation there, what he should have done is he should have asked for a copy of the divorce decree to show that she is the sole owner, that she, and even actually the buyer's agent. Like, so if you're the buyer's agent and you look at online, and you see two people own it, right? And you get a contract back with only one name on it, right? You got to ask, okay, what's going on? If just like in this situation, where the person says, oh, she's getting the property and divorce, okay, even as a buyer's agent, say, can I get a copy of the divorce papers to review it, to make sure she's the sole owner? If you do get a copy of that and you don't understand it, you're always welcome to contact me and say, hey, can you take a look at this just to make sure she can sell the property on her own, Because guess what? Let's just say you had the buyer in this situation. Let's say your buyer did their inspection. They did their appraisal. They just spent $1,000. And now you have to tell them, sorry, you don't have a contract because I didn't get the right people to sign. Your client's not going to be too happy with you and probably never use you again. So, make sure, like I said, you get all the sellers, the right sellers, and they all sign. Okay. Another thing that comes up a lot with sellers is when, let's say, when someone passes away. Okay. Now, there's situations where the deed will say husband and wife. Okay. So if a husband and wife own a property together and one person dies, the other automatically gets it. Okay. Now, all you have to do is show the death certificate to the county and it's automatically transferred. Now, there's situations also where the deed will say with right of survivorship. In that situation too, when one person dies, the other automatically gets it. All you have to do is show the death certificate. Now, there's situations where one person owns the property by themselves, or it has multiple people, but mentions no mention of right of survivorship. Okay. Even if, let's say, the person's married, but just has just their name on it, and if that person dies, it has to go to what's called probate. Probate's basically where the court, appoints someone, what's called a personal representative, to sell the property, actually, sign all the documents. And of course, the judge is going to state what happens to the money. Okay. Now, what you have to look out for is basically, if you ever have the situation where someone passes away, get them to a probate attorney right away, because probate could take a couple of months. It could take 2, it could take 3 months. So the sooner they get it done, the better it is. So for instance, like I had one a couple of years ago, I remember it was like in Weston, it was like $700,000 deal. And the seller passed away, the father, and the realtor met with the 3 kids. They wanted to list the property. He took the listing, listed it. He ends up, finding a buyer for the property. So like, $700,000, here he's getting 6% on a $700,000 deal. That's a nice commission, right? Well, here was the issue. They had to do probate. So what he did now, he referred to kids, you should go do, you need to do probate to sell the property. So they started doing the probate process, and it was taking longer than expected. And the buyer didn't want to wait around and ended up canceling the contract. Okay. So basically, because the realtor wasn't really proactive and got them to the right people immediately, he really cost himself a 3% commission, on a $700,000 deal. What's that? Isn't it like over $20,000? So get them to the right people immediately, Another thing too, like once I remember had a deal where, it's also sometimes too, is I remember one situation where same thing. I had a contract, had one name, and the deed, and I see the property appraisers had a different name. So I was asking what's going on. And it was the son. He's like, well, my mother passed away. Here's the will. The will says I get the property. He thought that just because he's in the will, it's automatic. Okay. It's not automatic. He still has to go through probate. He will get the property. He did end up getting the property, but there was extra steps. So I'm saying, so whenever you're dealing with like a situation where there's a death, definitely, get advice to make sure everything's fine, that there's no issues, that the person, who you're dealing with can sell. And if probate needs to be done, that from the beginning and it gets done. Someone actually just asked about LLCs, right? Now, there's a website called sunbiz.org where you can look up a company. Okay. Now, let's say you're dealing with an individual and you look up on Sunbiz and you see that individual is the president. Okay. You're dealing with the right person. You're good to go. Okay. Now, let's say you look up this person on Sunbiz and you don't see their name nowhere to be found. Now you got to ask more questions. You got to ask, okay, what gives you authority to sell the property? Is there a corporate resolution? Is there an operating agreement? What gives you authority to sell the property? And ask for that documentation, because without it, this person might be selling the property and they have no authority to do it whatsoever. Now, with a corporation, the president has full authority to do whatever they want with no other signatures. Okay. With an LLC, of course, if it's one person, that person has full authority. Now, if there's 2 or more members, either all have to sign, or you have to, like I said, get an operating agreement that allows one person to sign. So once again, you have to ask for that information. Once again, if you don't understand it, you're always welcome to contact me. Hey, can you take a look at this and just make sure that this person can sign for the company, But once again, if it's a corporation, the president has full authority to sign. If it's an LLC, you know, if it's one member, they can sign, but if it's more than one member, then you definitely have to get the corporate resolution or the operating agreement to determine who can sign. What else? Let me think. Trusts, had this happen before. You know, a lot of properties are owned by a trust. Same thing, always ask for a copy of the trust agreement. See, the trust agreement, actually, I just reviewed one for someone yesterday. And this is what happened. The people actually passed away. So she was asking me who can sign. The trust agreement is going to state, you know, who the trustee is, but also going to say what's called a successor trustee, meaning who can sign if the trustee, you know, passed away or is not able to sign. Okay. We had this happen a couple of years ago. I remember where the trustee was an elderly lady. She passed away, and the granddaughter called the realtor to list the property. You know, the realtor meets with the granddaughter, takes the listing, gets it under contract. We're doing the closing. We asked for a copy of the trust agreement. And guess what? The granddaughter's name is nowhere to be found there. She had no authority to sell that property. You know, in that situation, it was fine because we were lucky. The family was all on good terms and we got the right person to sign. But let's just say it was a family that everyone was fighting. You know, once again, let's say your buyer did their inspection, they did their appraisal, spent $1,000. Now you got to say, sorry, we don't have a contract because I didn't get the right person to sign. So when you're dealing with a trust, same thing. If you ever see like you know, the trustee is this person and then you get a contract signed by somebody else, ask why. You know, get a copy of that trust agreement, make sure, you know, you're dealing with the right person. Okay, Yvonne asked, what if an attorney is representing the family? They will not disclose all information. I mean, Yvonne, you're welcome to mute yourself if you want to explain better, but I'm not sure. I mean, if the person's selling the property, the buyer has the right to know that they're dealing with the right person. I mean, if the person won't disclose whether or not they have authority to sign, you got to actually, to me, that's a red flag.
I had a buyer who we submitted an offer, and the property, we found out just before we closed that the property was in probate. However, I had asked the agent the information that you're telling us that we needed to ask. And he says, no, the lawyer is representing us and he's taking care of everything. And 2 weeks before closing, we found out that there was one person who refused to sign. So we had to wait. And thank God my buyer was willing to wait. So we actually waited 4 months before the property got through probate. But they just wouldn't disclose anything to us. And I made several attempts to call the attorney. We tried to speak with him. They were just so close-lipped, and they were like almost insultive towards me, as if I didn't have the right to ask those questions.
I mean, to me, it just sounds like that attorney you were dealing with really maybe doesn't do real estate because, you know, you are the buyer. You have the right to you know what's going on and be kept up to date. I mean, I don't understand, you know, the ultimate goal for everybody is to close, even the seller. I mean, even let's say that, you know, the kids who inherited the property, I'm sure they want to sell and make money. So like why they wouldn't cooperate it just sounds, you know, I don't know. I don't want to say anything bad about people because I don't know who that was, but
Well,
I'm thinking the same. No, I'm going to say the same that you are saying. I think the attorney didn't know what I was doing.
Yeah, because as I said, our ultimate, you know, there are a lot of attorneys out there that are more like deal breakers than deal makers, you know, and you know, but to me, it seems like, you know, the more educated everybody is, because as a buyer, if you're not being told what's going to go on, what's happening, you're probably going to you may want to cancel. But if you at least know what's going on, hey, listen, you know, everything's in court, you know, we just need another 2 weeks to get the court approval. Your buyer's going to be, you know, more reasonable and not be, you know, scared and, you know, upset. So I don't know. It just sounds like it was just a bad situation for you. Hopefully it's not always like that.
Well, it was a learning experience. I'm actually glad I went through it because I learned so many things from this one transaction.
Yeah, and that's just like all of us. Everything you do, that's you got to take it as a learning experience, you know. You know, so the next time you're around, you kind of know, you know, more how to handle it. Maybe from the beginning, ask more questions, you know, and make sure and see who's handling the probate, and maybe even speak to them before the contract's even accepted to find out what's going on. Okay, so a seller still. Let me think what else. Power of attorneys. Okay, a lot of times you might be with someone, they say, well, I have power of attorney over my mom or something like that. I could sign for them.
You know, Giovanni,
Yes.
I have a question that goes
Sure.
back to the property being in probate. Is it required by the listing agent to put it on the listing that it is in probate?
Well, here's the thing. Technically, until the probate's done, they really can't even sell the property because whoever's selling it has no authority to sell it technically.
Right,
Because-
because I've seen listings where they say it's in probate and it could take up to whatever
But
period of
that's what
time.
that's what I'm trying to say. The person selling
So
the property.
that would deter buyers who are ready to move, you know, who
Yeah.
are looking to move ASAP from taking or even looking at that property as an option. And that's why I'm wondering if there's somewhere under the law, it is required that if it is in probate, that they state that on the listing.
I think it's definitely better to disclose. That's one, because of course, but technically, like I said, unless the probate is really officially done, where the judge appoints someone as a personal representative, authorizes the sale, whoever's signing that contract really is nobody. I mean, so technically you don't even have a contract, really, because that person who signed that contract doesn't even have authority to sign it yet. You know, so really, and I mean, people do list properties all the time before the probate's done. I see it all the time. And, you know, we get contracts all the time where the probate's still in process. But in reality, you don't even have a contract until the judge actually signs an order authorizing someone to sign. So I would definitely disclose it, because as a buyer's agent, if my client spent all this money and then find out the person who, like, you know, this realtor didn't disclose it, and now you have nothing, you know, I think your client's going to be pretty upset and probably want to be reimbursed that money. So yeah,
So as a buyer's agent,
Giovanni,
yes.
if you see if you see that a listing or you check the records, the property records, and it's in a trust or something to that nature, where you know that it could be going through probate, it's best to ask for the release of probate or the signer of the.
Yeah, they ask for the probate documents, so what's called like the letters of administration, you know, or authorization to sell. Yeah, so you can review it. And as I said, once again, if you're not sure about it, you're always welcome to contact me. Even if I'm not doing the closing, hey, can you just take a look at this and just let me know what you think? You know, and then
what I do is when I know that is the situation, I ask for the personal representative appointed by the court. When I got a person, I can get the listing. Before that, I will not take nothing.
Yeah, because like I just mentioned, technically, until you actually have that thing from the court, you know, appointing someone as the personal representative, no one's really authorized to sign. Michelle, you got a question?
Oh, no.
No?
Oh,
Yes, well, I typically, when I'm doing a contract, the first thing I do is go to IMAP and get the tax records to see who is actually on the deed that owns the property. Because that, if I see a name that's you know, in the contract and there's two names on the tax information, already it's a red flag. So I mean, isn't that
exactly? If you see something's not matching, you know, just like you said, like you see the property appraiser has two names on it, and you get a contract with one name, maybe maybe it was that situation where it's like a husband and wife and one passed away, but that's where you would want to see the death certificate.
Right.
You know, just don't go by their word. You know, I mean, you think like you're, I guess, being disrespectful or something by asking for that, but technically, you know, you want to know, you don't want to waste your time.
Right, exactly. Okay.
But once again, going back to the power of attorney thing, if you ever meet with someone, they say, let's say I have power of attorney over my mom, you know, I could sign for that person. Have the power of attorney reviewed, because especially in Florida, a power of attorney has to be real specific in order to be able to sell a property. Like for instance, in Florida, you have to have 2 witnesses. In some states, you don't have to have any. Like let's say Ohio, you don't have to have any witnesses. So they could have to prepare in Ohio with no witnesses, and they can use it in Ohio, but they can't use it in Florida. So, you know, you want to make sure the title company or the attorney, whoever's doing the closing, is going to accept it. So at the last minute, you're not scrambling, you know, to get one signed. Also, another important thing to know is when a person dies, the power of attorney dies with them. Like for instance, you know, we had one, I remember years ago, where we're doing the closing, the seller passed away, and all of a sudden the son appears and says, oh, I have power of attorney for my dad, I can sign for him. No, once the dad dies, the power of attorney dies, the son can't just keep using it. So like that situation, now the son had to do probate to be appointed to be able to sell the property. So as I said, sometimes they don't know. It's not like they're trying to commit fraud. Sometimes they just don't know the extra steps they have to take, and that's why you need to guide them properly. I'm just trying to think if I missed anything else. Okay, one last thing with sellers, I guess. I mentioned before, husband and wife, right? What's important to know, let's just say you look on the property, you're called on a listing appointment to sell a house, and you look online and the property is owned by one person, okay? And you go to the house, and now you see this is the person's married, their spouse is there. You see it's their primary residence, you know, their homestead, where they live. If the person is married, and even though the deed has just one name on it, and it's their homestead where they live, both have to sign, okay? Even if, let's say she owned it for 10 years and she got married a year ago, and he has to sign as well. Doesn't mean they're entitled to 50-50, but they both have to sign the listing agreement and they both have to sign the contract. And of course, the closing documents. Without that, you have nothing. So if you, like I said, if you go on a listing appointment, you see the person is married, regardless of who's on the deed, they both sign. Now, let's say the person calls you and they want to sell an investment property that they own alone, but they're married, then just that person signs. So if it's an investment property, just whoever owns it signs. If it's a homestead and they're married, they both have to sign regardless, okay? So I guess that's it. So like, you know, just line one, sellers, it sounds so simple, but there's so many things that can occur. But the main thing is really, you know, make sure you have all the sellers, the right sellers, and if needed, get the proper documentation to back it up. And once again, like I said, if you don't understand the documentation, you know, feel free to contact me anytime and I'll gladly look at it for you and, you know, give my opinion. I'll make sure you have the right sellers, because without the right sellers, you do not have a contract, you know. So, and then, you know, like I said, you're putting your buyer at risk of losing money. Any last questions with that before I go on?
Yeah, hi, it's Phil here.
Yes.
On the homesteading, you know, if we're doing this authenticine or dot loop or whatever, then we have to have a contact in, and that contact would automatically end up on the seller. So even though there's only one name on the deed, the property is homesteaded, it's okay to have Mr. and Mrs. up there, even though it's only Mr. owns the property, because we do need that extra space down there to sign for the other spouse. And what happens if they're not married? Maybe it's they're joint owners. How does that?
Okay, well, of course, if they're joint owners, if you know, they both have to sign, because that means they're both on the deed. But let's just say they were, you know, in a long-term relationship, but they've been living together, but it's still in one person's name. Some states recognize that, Florida does not. So even if people were, let's say, living together for 10 years, but the properties and not married, and the property's only in one name, just that person signs. Technically, the way Florida looks at it, the other person has, you know, no rights. So it's kind of sad, but that's the way that Florida looks at it. Okay. All right.
Okay, so it's okay to have, even though the Mr. and Mrs. aren't on the deed, you can put Mr. and Mrs. on the seller line.
Yeah, definitely. Okay,
thanks.
All right. The next section I want to talk about is line 15, personal property. Now, this section is the items that the seller is supposed to leave the buyer at closing. And if you go through this list, you know, it states like range ovens, refrigerators, dishwashers, you know, and so on. So there's a couple important things that are missing from there. One is washer and dryer, which to this day, I have no idea why it's not in there, because that is a common item that you do see in pretty much every house. So basically, you see where it said line 21, other personal property items, including the purchaser, you would have to write washer and dryer, because if you don't, the seller can actually take it, which is interesting. You know, I had one not too long ago where actually there was an argument. There was a pool at the house and the buyer expected the seller to leave all the pool cleaning equipment. Seller took it. And they're arguing about this the day of closing, but guess what? The seller did nothing wrong. If you go through this list, there's no mention of pool cleaning equipment. So once again, if your buyer's expecting something, make sure you write it in there. Also, if your seller wants to take something that's from this list, you know, make sure you write it in there. The following items are excluded from the purchase. Like, for instance, just 1 second, sorry. Well, Chris, just real quick, going back to the thing about the sellers. Chris asked about common law. There in Florida, there is no common law marriage. As I said, some states do have that, but Florida does not have common law marriage. Okay, so back to the personal property. Like, so for instance, like here, refrigerators. You see that right there? This happens all the time. You go see a property. There's, you know, it says beautiful stainless steel appliances, and 1 second, please. Okay, so if it's like refrigerator, you go see, and what happened is this happens a lot. You go the day of closing, you go do a walkthrough, and guess what? Those stainless steel appliances are gone. Okay, technically, if the buyer sued the seller, the buyer would win, but your goal is to have a smooth closing, okay? If everyone's fighting the day of the closing about the appliances, that's what they're going to remember. You know, you're once again, if a happy closing, you're going to get referrals. If everyone's arguing, you're not going to get referrals. So what you want to do is, you know, you want to try to make it as clear as possible. So, you know, as I said, even though the seller is required to leave those things, you know, but you can't hurt to, you know, if you know your buyer really wants this, can't hurt maybe in additional terms put, you know, refrigerator model number, whatever, or take pictures and have it initialed, or if the MLS is real specific as to the appliances, you know, as per MLS. Another thing too, you see where it says refrigerators. This happened to us not too long ago. There was a refrigerator in the kitchen. There was a refrigerator in the garage. The seller left the one in the kitchen, but he took the one in the garage, and the buyer's like, no, the one in the garage was mine too. And seller's like, no, that's not, you know, included. Well, guess what? I think the buyer's right, because he says right here, refrigerators with an S. Okay. I think if the seller wanted to take that refrigerator in the garage, they should have put right here. The following items are excluded from the purchase, refrigerator in the garage. Once again, be as clear as possible. Light fixtures. This happens all the time. You go see a house, there's these beautiful chandeliers, and guess what? The day of closing, the chandeliers are gone and there's some cheap lights up there. Okay. Even though the seller is supposed to leave those, once again, try to be as clear as possible. If your buyer's expecting that chandelier in the dining room, you can't hurt to put, you know, that specific about that chandelier in the dining room staying. Or if the seller wants to take that chandelier in the dining room, the following items excluded from the purchase, chandelier in the dining room, you know, try to be as clear as possible. Let me think. Another thing, television wall mounts, television mounting hardware. So, you know, as you know, right now, a lot of people are hanging their TVs on the wall. And what was happening, people were just ripping them off the wall, pretty much. The way it works now is the seller does get the TV, but the wall mounting material stays on the wall. So you don't rip it off the wall, you leave that, but you do take the TV. Also, doorbells, this was added to the contract. You know, a lot of people have these Ring doorbells. They do stay. You do not take the Ring doorbells unless you put in the contract that the following are excluded from the purchase, you know, where you put Ring doorbell. So they do stay. Another thing, other personal items in the purchase are, I've seen this happen where this person sells the house furnished, right? Where they would just put furniture, let's say, right? Or furnished. And I've seen it where, like, I had one situation where, I mean, the seller left all the furniture, but there was artwork on the wall. And seller took the artwork, and buyer's like, no, the artwork's mine. Seller says, no, the artwork's mine. And they're arguing over this. Truthfully, I don't even know who's right or wrong. But guess what? I think your best bet to make is, once again, you want to be as clear as possible. What you want to do is an itemized list if you're selling house furnished. Go room by room, you know, dining room, 6 chairs, you know, living room, couch, whatever. And so this is what the buyer knows. This is what you're getting. You're getting nothing else. And that's it. So there's no argument. There's no fights the day of closing, which, once again, you want to avoid. Also, if there's something in this list that you know the seller doesn't have, it can't hurt to cross it out. Like, I have this happen almost every year during the hurricane season, or when there's a hurricane, you know, scare, the storm shutters, storm protection items. Okay. There's a lot of houses in Florida that basically have these like tracks for hurricane shutters, but a lot of people don't actually have the shutters. So if you know they don't have it, I would cross it out, because I've had that happen where the buyer's insisting on the storm shutters and seller says, well, I don't have any, and they're fighting over this. So I think if you know you don't have something in that list, it can't hurt to cross it out. Hang on. Yeah, Chris asked about an addendum with the furniture. Yeah, definitely you could. I mean, when you're selling house furnished, of course, when you're getting a loan, you got to be careful, because the lender, you know, may give that value or something. So you definitely want to put probably something that the furniture has no value. But yeah, it could be an addendum or just like a separate list. Let me think, anything else? Personal property. All right, I think that's it with the personal property. All right, the next section we'll talk about is the purchase price. Okay. Yes.
Oh, sorry, if I can, you know me. So lost my track there. Okay, we do have the chandelier, and this happened to me, you know, $5,000 chandelier. Me and the buyer on the final walkthrough, the buyer's wife said, I know that chandelier has been changed for some cheap one from Walmart.
Mhm.
So there's nothing really there that says, when I looked at this house and wrote this contract, I want everything to stay exactly the same. It's the same also with this, and I asked for the fridge in the rotten old rusty fridge in the garage to be excluded. When I move in, it's still there. No, I don't want it. Get rid of it. Is there any obligation there for them to remove stuff that you say you want excluded? Thanks.
Well, first of all, the contract does say, line 15 says the following lines which are owned by the seller and existing on the property as of the date of the initial offer are included in the purchase. So if the chandeliers were there, if that particular chandelier was there when you made the offer, it is supposed to stay. They're not
Okay.
supposed to change it.
You're right there. Okay. Ignore that.
Now, if the I mean, we're going to get further down about, leaving the property basically in, free, condition, like empty, basically. So yes, if this wasn't something they were supposed to leave and they're leaving it, they do have an obligation to get rid of those items. So, that's further in the contract where it talks about that. But yeah, they do have an obligation to get rid of if that's not something you agreed to accept. So the next section was purchase price. Now, what's important here is deposits. What you want to make sure is one, not only that you get the deposit, that you verify the deposit, okay? You want to make sure that you get what's called an escrow letter from the title company or the real estate company, whoever's holding the money. Not only that they have the money, that the funds are clear and available, okay? Because see, once the title company puts that in writing, now it's on them. They can't say, oh, we forgot to deposit the check or the check bounced or any other reason. It's on them. Okay. So it's really important to get that, because what happened, because truthfully, this happened to me a few years ago. A realtor came with me. She brought me a contract for like $1 million and she brought me a check for $25,000. And she asked me to not deposit the check, but give her a letter that I had the money. Told her I couldn't do it. I guarantee you in South Florida, she found someone to do that for her. Okay. Now imagine you're the listing agent. You didn't get her an escrow letter. You think there's $25,000 in escrow and the deal blows up and you go make a claim on that $25,000 and there's no money there. Your seller's going to be pretty upset with you, So it is your job. And there's three things I'm going to talk about today that get realtors in the most trouble. And one of them is definitely deposits. You got to make sure you verify those deposits and get those escrow letters. Also, for instance, there's situations where there's two deposits, a first and a second. Same thing. Make sure you follow up and get that second escrow letter. I have a realtor friend going through that recently where the contract said 5,000 first deposit, 10,000 second deposit. He got the escrow letter for the first 5,000, forgot about the second 10,000. The deal blows up, goes and makes a claim on a 15, and guess what? Only 5's there. So what? Guess what? His buyer's not mad at his seller's not mad at the buyer. His seller's not mad at the buyer's agent. His seller's mad at him. You're my agent. Why didn't you protect you? Why didn't you make sure the money was there? So make sure you stay on top of those deposits. Another thing too, if you ever get a contract offer with an escrow letter attached, once you go to contract, contact the title company, whoever's supposedly holding the money, and get a letter specific to your deal, okay? Because what happens, a lot of people will attach old letters or fake letters to these offers, okay? And there's no money there. And then realtors thinking that the money's there, never follow up. And guess what? There's no money ever made. And then the deal blows up and there's no deposit. We had this happen, recently to us. We had a realtor. She kept calling us for an escrow letter. We kept telling them, we don't have the money. We don't have the money. We don't have the money. Finally, she called one day and she said, I just want to verify that you have the money. And once again, we said, no, we don't. She's like, well, I have an escrow letter from you. And I'm like, it's impossible. We don't have the money. I said, can you send me a copy of the letter? She sends it to me. And guess what? It was fake. The buyer made a fake letter saying it had like $20,000. But luckily she was smart. She, felt something wasn't right and contacted us, So, but imagine if she didn't contact us and the deal went on for like 30 days or so and then find out there was no money, because I think what this person was trying to do, they were trying to like wholesale it, probably trying to find somebody to buy it for more. And of course, then, then they would have closed. And if not, they would have just canceled. So things like that do happen. So make sure you stay on top of those deposits. Like I said, three things that get realtors in the most trouble. One is definitely deposits. And something I'm going to talk about a little later, when a deal blows up, if the seller defaults and there's money in escrow, you, the realtor, can actually get some of that money. There's situations where a lot of people don't know about. So deposit not only protects the seller, it protects you, the realtors, because you could actually get paid if the buyer defaults, believe it or not, which we will talk about. Next thing we'll talk about is line 43, where it says time for acceptance of offer, counter offer. Okay, line 45, that blank line, what that is when you submit an offer, you give the seller a certain amount of time to respond. Okay, so one, you always want to put something there. You do not want to leave it blank, because if you leave it blank, the seller could come back a month later and says, I accept your offer. Okay, but what if your buyer doesn't want the deal no more? So you want to have an end date. So let's just say you gave them till Friday. Well, I think Friday is I believe the November 3rd. So let's just say you put on there on or before November 3rd. Three things are going to happen. The buyer's either going to accept your offer, and of course you're under contract. The buyer's not going to respond and you have nothing. or the buyer is going to make a counteroffer. Now, if the buyer makes a counteroffer, the way the contract's written, what happens is now you have 2 days to respond. So the first offer is what you make, you write there. After that's 2 days, 2 days, 2 days until either you have a contract or one party walks away. Okay. Now, let's just say you gave them to Friday to respond, and on Saturday, the seller responds and says, I accept your offer. Okay. But you gave them to Friday. Now the ball's in the buyer's court. The buyer could say, no, I gave it to Friday to respond. You responded Saturday. I don't want the deal. Or the buyer could say, you know what? I gave it to Friday to respond. You responded Saturday. I still want the contract. Let's proceed. So even though they respond after, you could still proceed, but you can't force the other party. Okay. But once again, make sure you always put a date there. Do not leave it blank. Also, effective date. Now, effective date is really important because that's the day you actually have a contract. Okay. And that's when all the time periods start. Okay. Now, let's just say today, October 31st, you went under contract on a deal. Okay. The way this contract works, everything is calendar days. So meaning tomorrow would be day 1, Thursday, day 2, Friday, day 3, Saturday, day 4, Sunday, day 5. So you do count Saturdays, Sundays, legal holidays when you are counting. Okay, with this contract. There are other contracts there, like the Chris contract, things are business days. With this contract here, everything is calendar days. Okay, so you do count Saturdays, Sundays, illegal holidays. Now, if let's say the last day of your inspection ends on a Saturday, then you go to next business day midnight. Let's say your loan approval period ended Sunday, you go to next business day midnight. Okay. Let's just say your inspection ended today, it would be midnight today. So first of all, everything is midnight, just so you know. But once again, it's a little confused, but when you're counting, you do count Saturdays, Sundays, legal holidays. But if the last day is a Saturday, Sunday legal holiday, you go to next business day midnight. Okay. Now, let me just look at if there's any questions here real quick. Hang on. What's someone Chris just wrote, talk about counteroffers more in details. I mean, once again, as I said, you do, once your initial offer is made, the other person has 2 days to respond. If counteroffer is made, you do not have a contract, and that's what I was just gonna say, until both parties agree on all terms. Okay. So if you're still negotiating back and forth, you do not have a contract, or if there's initial missing or whatever, you don't have a contract. So, but once the parties agree on everything and it's delivered, and that's what I was just gonna talk about now, the effective date, when it's delivered, that's when you actually have a contract. Okay. So it's really important to establish the effective date, because in this contract, there's nothing that says the effective date is this. Okay. So let's just say today on October 31st, you got a contract back from the sellers, but you notice it was signed on October 28th, but you received it today. The effective date would be today, October 31st. Okay. And that's why it's really important now to establish the effective date. One, either I would send an email to the other side saying, hey, this confirms the effective date is October 31st. Or what some realtors do, they do like a timeline. Okay, effective date is October 31st. Deposits due November 3rd, inspection due November 10th, loan approvals due November 30th, whatever. So you're on the same page. Because why is this important? Let's just say your client had 30 days for loan approval, and on November 29th, they were denied, right, for the loan, and you contact the seller, hey, we were denied for the loan, we want to get our deposit back. There's a good chance the seller is going to look at the contract and see it was signed on October 28th and say, no, you had till November 28th to cancel. That's 30 days. They're not going to remember in 30 days that they sent you the contract on October 31st. They're going to just look at the date in the contract. But then if you could go to your emails and say, no, look, here, I confirmed with you that we received the contract on October 31st. And, we had till November 31st, for the loan approval, or 30th or whatever it is, So once again, really important to establish the effective date. Like this happens a lot too. Let's say it's 10 o'clock at night, you go to bed, you wake up in the morning and there's a contract in your email, right? But it was sent at 11 o'clock last night. When's the effective date? Technically, it's the night before. It's when it was sent, because it was sent before midnight. Even though you open the email the next day, it was sent the day before. So once again, there you want to make sure you communicate with the other realtor so you're both on the same page, because one day can cost your client their deposit. So it's really important to establish the effective date. Okay, you guys good so far? Okay. The next section, closing date. Okay, a second. Okay, so the closing date on the top of line 53, right? There's a blank space, and now that's the day you plan on closing. Once again, always put something there. Do not leave it blank, okay? Because if you leave it blank, technically the buyer can say, oh, I want to close a year from now. And really technically it could, because there's nothing in the contract that states, I'm sorry, because when the closing date is. Okay, so you want to put something there. How much time do you need to close? Technically, if it's a cash deal and there's no association involved, we can usually close easily within 2 weeks. On a side note, we just did a closing within 10 days. We just closed one. So, but if there's an association, I would always definitely do at least 30-day closings. Now, if there's a loan, always speak to the lenders. Speak to the lenders. Say, hey, how much time do you need? Do you need 30 days, 45 days? And use that as a basis for their contract. But definitely, once again, on average, I would say 30 days. And make sure you put something there.
Giovanni, I have a question about that. Many times agents will put on or before.
I was just going to talk about that.
Okay.
Okay. So the on or before, in my opinion, really means nothing. Here's why. Let's just say this contract said closing on or before November 5th, right? And today, October 31st, the buyer's ready to close. And you say to sell, hey, I'm ready to close today. Can you close today? And seller says, no, you can't force them to close today. So putting on or before really has no strength to it. You know, even if the contract says closing on November 5th, but today on October 31st, buyer and seller are both ready to close, you could still close early. So, you know, putting on or before, I mean, you could do it, but it really has there's no power to it, I guess you could say. You can't, unless both parties are ready, you can't close earlier. You can't force the other person to close early. So can you put it? Yes. But there's, you know, like I said, there's really no strength to that clause. So even if it just said on November 25th, the parties can still close earlier, you know, if they both agree. So I hope that answers your question. Okay.
Can I just go back a little bit there with the undetermined dates on the first page where you put down the escrow agent? We still see there to be determined. What's your opinion on that?
Escrow agent?
Yeah, on the first page.
That's sometimes fine, because sometimes, I mean, you should actually, okay, just so you guys are aware, the escrow agent doesn't have to be the closing agent, because a lot of people think what you're putting there is the escrow agent and also the closing agent. So one person could actually be the escrow agent and someone else could be doing the closing. Like, you know, in certain areas, the seller picks title. So as a buyer's agent, you know, you don't know who's going to be the title company. So that's why sometimes, a lot of times I see to be determined. But technically that buyer's agent could really be using their title company to hold the money and then just the seller's title company to be the closing agent. So really probably putting to be determined is probably not the right thing to do, because technically it really is two separate things. The escrow agent is one thing and the closing agent's another thing. And that could, you know, once you go under contract, you know, you could decide who's going to do the closing. But the escrow agent is just really the person holding the money. Okay. Now, paragraph 5 says extension of closing date, and we're going to get back to that. I'm going to talk about paragraph 6 real quick, occupancy and possession. Now, occupancy and possession mainly deals with, well, one of the big parts where it causes a lot of problems is with tenants, okay? If you're ever showing a property and you see tenants there and your buyer's telling you, I want to put an offer on this property, right? Before you do that, you need to find out what's your buyer's intentions, okay? Now, are they going to live in this property or are they buying it to rent it out? If they're buying it to rent it out, it's simple. You just check off 6B, check a property subject to lease or obviously after closing. This means the buyer assumes the tenants, assumes the leases, assumes everything, okay? Now, if your buyer is telling you, no, I want to close by November 30th and I want to live in this property. Now you got to ask, well, one, you don't check off anything. And now it's the seller's obligation to get the tenants out by that day. But here's the problem. It's not easy to get a tenant out. Let's just say they have a lease good through February next year. The new buyer has to honor the lease. Like I've had situations where the new buyers think, okay, I'm the new owner, I can do whatever I want. No, if there's a lease in place, you have to honor that lease. Also, let's just say the tenants are not making payments. Now you have to evict them. It could take a few months. So if your buyer's telling you they want to live in the property and there's tenants there, you need to find out what's the situations with the tenants. You know, are they going to be out by November, let's say 30th? Because if they're not, there's no sense going under contract, because what's going to happen? November 30th is going to happen. Your buyer's going to want to do a walkthrough. The tenants are going to be there. Now, guess what? Now your buyer's going to be all upset that the tenants are still there. They're not going to want to close. They're going to cancel the contract, and you just wasted 30 to 45 days. So if your buyer wants to assume the tenants, you check off 6B. If your buyer wants to move in with no tenants there, Don't check anything, but ask questions. Make sure you feel comfortable that the tenants will be gone by the closing date before going under contract, before submitting an offer, because if not, you're just wasting your time. Okay, you guys got that? All right, the next paragraph,
One
assignability.
question, Giovanni.
Yeah.
The 6B need to be filled out by the listing agent or us? Because really we as a buyer agent, we can see the person there, but we're not sure. I think the
Well,
person,
I mean, I guess truthfully, no, the buyers ain't should, I mean, I guess, by you should really, one, either they may a lot of times put on the MLS if it's tenant occupied, or two, of course, by asking questions. I mean, they can't lie to you and say, no, there's no tenant and someone's living there. So if you see something that looks like a tenant, I would definitely, as a buyer's agent, know what's going on. Yeah, but that 6B would definitely be filled out by the buyer. But I mean, I know most of the times, if it's tenant occupied, they'll put it on the MLS, but I'd say it's the buyer who would fill that out. Okay. All right. Assignability. Okay. Paragraph 7. Okay. This is where basically someone goes under contract with you and wants to assign it to someone else. Okay. Now, a lot of times when you hear about assignability, what is this, like wholesalers? People will try to go under contract with you, and then they will try to find someone to buy it more and assign the contract to them. Okay. As a listing agent, this is definitely something you want to look out for when someone's saying they want to assign. Now, there are valid reasons. Maybe the person wants to form a corporation and the corporation is not ready, so they want to assign it to their corporation, or maybe they want to do a 1031 exchange. So that's a valid reason. But any other reason you got to look out for. So there's 3 options: may assign and they'll be released from liability. You never want that, because then you have nothing. They could just assign it to a fake person and then they're out of the contract. May assign but not be released from liability. That's a little better. And the last one, may not assign, which is probably what you want, because you really, don't want them wasting your time if they're serious buyers. Now, what wholesalers did, they got smart. They realized, okay, if nothing's checked, you can't stop them from assigning it. So they added actually to the contract that says, if no box is checked, then buyer may not assign this contract. So it's a wholesaler. If no box is checked, they cannot assign the contract. So that was actually added to the contract. Now, this is actually a little trick I see a lot of wholesalers doing now. They'll put in there like their name, and they'll put that they may sign to an LLC. And the way they're making it seem is they're going to assign it to their LLC. Well, guess what? They find a buyer that's an LLC and then want to assign it to their, and technically they could, because they put in the contract may assign to an LLC, but they give the impression that they're going to assign it to their LLC, but really they're just finding another buyer who's an LLC, and there's really nothing you could do because you agreed to it. So look out for that as well. Let me just see something. Okay. All right. So the next section, financing. Okay. Paragraph 8A.
Giovanni, quick question.
Yes.
So if they say they want to assign it to an LLC, then they need to spell out that LLC
Well,
that they own, that they're.
But what they may tell you is that this LLC is not done yet, that they're trying to form it. As I say, they're basically tricking you, So
Right. So then basically we're going to leave the contract in it. When you have that LLC, then we can do a new contract.
Yeah, as I said, some realtors ask more questions and some don't, but the right way would be, to ask more questions and find out exactly what they're trying to do, because they're basically deceiving you. They're saying, yeah, we're trying to form an LLC. We want to, and then they just put in really simple, like assign to an LLC. And then, like I said, then they find another buyer who's an LLC and assign it to them and make money. Not that I got anything against wholesalers. I just think, just be honest about what you're doing.
Right. Exactly.
Yeah. Okay. Paragraph 8, financing. It says, number 8 says, this is a cash transaction with no finance contingency. Okay. What's important here is make sure you get proof of funds. If you're the listing agent and you get an offer, make sure they have the money. If you're the buyer's agent and they're asking you to show property and they're saying cash buyers, make sure they have the money. You don't know how many people in South Florida will just waste your time. They will look at properties, they will show offers on properties, they'll go under contract with properties with not a penny to their name. Why they do this, I have no idea, but they do. Also, like example also too, if a person is getting a loan and they have pre-approval letter, make sure they have the money to pay the difference. Like actually, you know, this a realtor I know, she just happened to her. She was showing a property to somebody. It was like 1.3 million, you know, really happy that, you know, they got under contract or they submitted the offer. The person has a pre-approval letter. And the listing agent was smart. I said, okay, I want to see, you know, proof of funds for the difference because they're, you know, supposedly going to, you know, getting an 80% loan. And the buyers like didn't have it. So technically, like this person was looking at these properties for 1.3 million with having no money. And a pre-approval letter truthfully means nothing. I mean, there are, you know, lenders who are really strict with giving a pre-approval letters, but there's lenders out there that you just ask them, hey, give me a pre-approval. Like, we're not even looking at your financials. Boom, they write you a letter. There's actually websites online where you could just put in your information, put in the property address and print a pre-approval letter. So a pre-approval letter truthfully really doesn't mean too much, but make sure they really have the money. You know, we had a deal, this was a few years ago, where it was like a $450,000 deal with, I think it was like 5,000 or 10,000 in escrow, and the check bounced, right? And the buyer's agent did the right thing. He immediately contacted the buyer. Hey, you need to replace the money. Here's the buyer's wire instruction. I mean, title company's wire instructions, this, that. Kept calling her, texted her, emailed her, called her, and she disappeared. And the listing agent, thinking he was smart, tells the seller, hey, you should sue the buyer. What do? They get an attorney, and they sued the buyer basically for breach of contract. But not only that, they sued the buyer's agent and buyer's broker, saying that they didn't do their due diligence to make sure this person had the ability to buy their house. Well, guess what that real estate company does? They get their attorney involved. And what does that attorney do? Sues the listing broker. Well, if we didn't do our job for asking for proof of funds, you didn't do your job either. And they're all involved in a lawsuit because no one asked for proof of funds. Okay, and who's the only one who makes money there? The attorneys. Get proof of funds. Okay, make sure you get proof of funds. That's just so important. The next thing, loan approval period. Now, this is when your buyer's getting a loan, they have a certain amount of time to get approved for the loan. Here it says 30 days if left blank. Whatever it is, whether it's 30 days, 25 days, 45 days, know how many days, okay? Because this is, like I said, probably the next thing that gets realtors in the most trouble, not knowing the time periods, okay? Like I had a realtor not too long ago, her client was denied on day 28. She thought the client had 30 days. Guess what? She looks at the contract and it was written in there 25 days. So now her client is losing her deposit because she told them the wrong amount of days for loan approval, okay? Know what's written in there. Now, if your buyer acts in good faith, meaning truly tries to get a loan and they are denied or not approved during this time period, they can cancel, get their deposit back, okay? Doesn't mean they have to be denied. If they're trying to get the loan, but they're not approved yet, they can cancel, get their money back. Now, let's just say they have 30 days for loan approval. It's day 29 and your buyer's still not approved. You need to protect your buyer. You need to either 1, cancel the contract, or 2, ask for an extension to the loan approval period. When I say an extension to the loan approval period, you would basically do, you know, if seller agrees, you would do an addendum, you know, buyer and seller agree to extend the loan approval period, let's say 10 days. You have to be specific to what you're extending, you know, so have to say loan approval period. You know, what a lot of realtors do, they'll just extend the closing date. Well, guess what? Extend the closing date just extends the closing date. It doesn't extend your loan approval, doesn't extend your inspection, it just extends the closing date. So be specific to what you're extending. So let's just say you ask the seller for 10 more days for loan approval. And the seller says, okay. Make sure.
Giovanni,
Yes.
I want to add something of this. In order to protect my clients, always I put the loan approval 4 days or 5 days before the clear to close. Why? Or the closing day. Why? Because sometimes most of the time the loan approval are conditional loan approval.
Yeah.
And always the underwriter 2 days or 3 days can ask for anything that maybe the buyer didn't have. So if I have submitted before that condition approval to the listing agent, it's like I give a waiver for the loan approval in the deposit is a risk. I'm right?
Yeah, I'm gonna talk about that in more detail.
Okay.
So, but one thing she just mentioned, which I see a lot of realtors do, and as a listing agent, you got to look out for this. They'll put, let's say, a 30-day loan approval and 30-day close. So guess what that means? That means the buyer can cancel at any time. Okay. That means the day of closing where your seller has their moving truck and they're loading their truck to move out. And then you get a call from the buyer saying, oh, we're not approved yet, we're canceling. Okay. Your seller's not going to be too happy with you. So make sure, especially as a listing agent, that the loan approval date and the closing date are not the same day, okay? As a buyer's agent, of course, you don't care because you're protecting your client for as long as possible. But as a listing agent, be careful for that because I see it all the time. Okay, so let's go back to the loan extension. So let's just say you ask the seller, hey, can we get 10 more days for loan approval? And seller says, sure, we're going to give you 10 more days, right? Now, make sure you have the addendum signed before the end of the loan approval. So seller sends you a text, says, yes, I'll give you 10 more days, means nothing. Seller tells you on the phone, yes, I'll give you 10 more days, means nothing. Seller sends you an email, says, yes, I'll give you 10 more days, means nothing. Get it in writing, signed by both parties, or it means nothing. Okay, so let's just say it's day 30, 10 o'clock at night. You still don't have it back in writing. Cancel the contract. Protect your buyer. You could always reinitiate the contract, but once you're past that day, your client is stuck. Okay, so stay on top of the date. So important, okay? Because as I said, this is probably the number 2 thing that gets realtors the most in trouble. Now, if your buyer is asking for, if the buyer's asking for, 10 more days, the contract does allow the realtors to speak to the lender. So you, the realtor, can call the lender and say, hey, and speak to them. So if you're the listing agent, you speak to the lender and you see, okay, this is definitely going to close. You give them 10 more days. If you speak to the lender, you see this is going nowhere, you cancel, you move on. Okay. But so that does allow you to speak to the lender. Another thing too, if you do get a loan approval, you are required to tell the seller you're approved, or the seller has 3 days to cancel. So let's just say today was the last day of the loan approval and buyer's approved, it doesn't say nothing. Seller technically has till Friday to cancel the contract. And what was happening when the market was going crazy, a lot of sellers wanted to get out of the deals because they thought they could get more money. And buyers were approved, but not telling the sellers. And guess what? The seller canceled. There's nothing the buyer can do now. So if you are approved, make sure you do tell them. Another thing too, and we're going to talk about the approval letters in a second. The contract also, like if you look at her line 94, says buyer's mortgage broker or lender having received an appraisal or alternative valuation of the property satisfactory to lender. So not only do you have to get the loan approval in the 30 days, the appraisal has to come back. Okay. So once again, make sure the appraisal is back in whatever days that are written here. So same thing, if your buyer's approved, but the appraisal's not back, and let's just say you get the appraisal, let's just say your buyer's has the approval, you tell the seller you're approved, but the appraisal's not back. And then on day 35, the appraisal comes back and it's low, you're stuck. So once again, make sure you get the loan approval and the appraisal back during that time. Now, there are situations where your buyers, technically this is kind of like an appraisal contingency right in the contract, but there are situations where, there's an appraisal addendum, which you would want to use the appraisal addendum. I think next Thursday, not this week, next Thursday night at 6 o'clock, I'm going to do a class on the addendums, and we'll go over the appraisal addendum in detail. But once again, you want to make sure you get the loan approval and the appraisal back during the loan approval period. If not, once again, either cancel or get an extension.
Okay, I guess. I don't know.
Okay.
Okay.
Is it better, Giovanni, is it better to put like 45 days, then this way you're covered?
Well, here's the thing though, your ultimate goal is to get the contract accepted. And if you
Okay.
put a 45-day loan approval, like actually someone came to me this morning and they got an offer with a 30-day inspection. Who's going to accept that? I mean, of course, for the buyer, 30 days inspection is great, but what seller's going to accept that? So yeah, 45-day loan approval would be amazing, but what seller's going to accept it? So, I mean, on average, I'd say it's 30 days, but once again, stay on top of it, so.
Okay.
I have a question, Giovanni.
Yes.
So if you've written the contract with the 30-day closing and 20-day loan approval, and you get the loan, because when you get loan approval, there are usually still some contingencies that have to be met. So if the contingencies are not being met in time for closing, then that takes on the need for extension of the closing date.
I'm going to talk about that next.
He's wanting to know, gotta figure out if I'm getting dizzy from getting up,
Hello?
from the blood pressure changing or what.
Someone's talking. I don't know if you can mute yourself.
Okay.
Hello?
I said so
Okay, so line 126.
I was just not feeling good all day. And I told my husband, I just, something didn't.
Someone's, I don't know if someone could mute. I'm not sure who someone's on.
So then I lay down and took a nap, and I was like,
You can mute the.
I know, I'm
mic
trying to figure out who. I'm trying to find it.
my heart started racing.
Phil and SH. That's the one who's speaking.
That happened before. So I grabbed off the table. I have a
Hang on.
box there, and I put it on.
What's the name?
And it was going up, you know. it was
Phil,
about
maybe?
100, 130,
Phil,
130.
PHILNSH.
One, busy second time, I'm going up to 140, 160, so I get it to my neighbors. And, you know, so
Hang
I
on.
total of 3 times 911 was busy, but anyways, he took me to the ER, naturally at the ER. They hooked me up to a monitor, I don't know what I was doing, but I know I looked at the pulse oximeter. I had it laying on my hand laying on his console, my friend that took me neighbor, and it was like 200. I quit looking at 200, but I got there. They hooked me up to cardiac. I told them I had some cardiac going on. They hooked me up to a monitor there, and then the next thing I know, I'm out in the hall setting. Oh, I'm so sorry you had to do that. I said, yeah, I'm just setting there. Well, anyways, it stopped, and then I had like
Hello?
Good.
Did we get him? Hello?
Yes. Yes.
Sorry about that. I apologize. All right, so let's try again. Hang on. All right, so where am I? Okay, okay, so we're talking about the loan approval, right? Where's it go? Okay, so basically on line 126. It states, if buyer has timely provided either written notice provided for in paragraph 8B3 above, and buyer therefore after fails to close this contract, the deposit shall be paid to seller unless failure to disclose is due to. So once you tell the seller you're approved, and if you fail to close, the buyer's going to pretty much lose their deposit unless 2 things happen. One is seller's default, meaning the seller fails to refuses to close, or 2 says property related conditions of the loan approval have not been met, meaning that let's just say the buyer's approved contingent on seller fixing the roof, and seller refuses to fix the roof. Buyer can cancel and get their money back, okay? But what's important here to know is once you tell the seller you're approved, you're stuck, okay? So other than these 2 reasons, there's no backing out. So buyer loses their job after you tell them you're approved, you're losing your deposit, okay? So that's why it's really important. Once you do get the approval letter, go through it with your buyer. Make sure they can meet the conditions, because you're never going to get an approval letter that just says you're approved. There's always going to be conditions. The lender's always going to try to protect themselves. There's always going to be something in there like that they have to keep their job, they can't take out more loans. But sometimes it's something major, or they have to pay off, let's say, a $20,000 IRS lien. Right? So let's just say your buyer's approved and they had to pay off $20,000 IRS lien. You tell the seller they're approved, and it turns out your buyer doesn't have that $20,000 to pay off that lien. Now they're going to lose their deposit, right? And guess what they're going to do? They're going to blame you. They're going to say, why did you tell them I was approved? I don't have that extra 20,000. They're going to blame you. So have your buyer review the approval letter, make sure they can meet those conditions, and have them sign it, so that this way they can't blame you that why did you give them this letter when I wasn't really approved? Because I'm telling you, that's the first thing they're going to do. They're always going to blame you. So definitely go through that approval letter and make sure they can meet those conditions. Hang on a second. Oh, we'll get back to that. Okay, hang on a second. Any questions with the loan approval section? Okay, I'm going to go back to page 2, extension of closing date, because I think that's the kind of what Wilson was just asking. Okay, so in October 2015, the government came up with this closing Consumer Financial Protection Bureau closing disclosure delivery requirements. And what that was is laws meant to protect the buyer, okay? Like, for instance, like when we had the last foreclosure prices, let's say 2006, 2007, whatever, people were coming to closings and they were just basically had no idea what their interest rate was, no idea what their closing costs were, no idea about anything, just basically sign here or you're losing your money, okay? So now what's required is, one, as soon as they go under contract, they have to, and they're getting a loan, they have to get what's called a loan estimate from the lender. And the loan estimate is going to tell them what their closing costs are. And it turns out that they're closing, their fees are a lot more over a certain percentage of what they were quoted. The lender has to credit them money. So of course, lenders want to make it as accurate as possible because they don't want to lose money. Second, 3 days before closing, they have to get what's called the closing disclosure with the final figures, and they have to approve it. So what this says is basically, in the event closing funds from buyer's lender are not available on closing date due to Consumer Financial Protection Bureau closing disclosure delivery requirements. If paragraph 8B is checked, which is the loan approval section, and loan approval has been obtained and lender's underwriting is complete, then closing shall be extended for such period necessary to satisfy CFE requirements, providing such period shall not exceed 7 days. So what that means is, for instance, let's say you're supposed to close today and buyer's ready to close today, but the lender does not get out the CD, the closing disclosure, till today. Even though buyer wants to close today, even though seller wants to close today, by law, they have to wait 3 days to close. So what this is saying here is you can't punish the buyer for complying with the law. So they would get an automatic extension in order to be able to comply with the law. So the seller can't say, no, either you close today or you're in default. Or the seller says, if you want more time, you got to pay me $250 a day. So it's right there in the contract. If the buyer needs more time in order to comply with the government laws and regulations, they can't be punished. They can get an extension automatically up to 7 days. Okay. Now, of course, if it's the buyer needs more time for their income tax returns to come back, no, that doesn't apply. It's mainly to deal with the closing disclosure to make sure the buyer has the 3 days to review it. And okay, you guys okay with that? All right, so we're gonna go on to closing costs. Hang on a second, see if there's any questions. Okay, all right, just real quick before I go on. Basically, you guys know, I think since October 1st, I've been doing classes every Tuesday, Thursday, and Saturday. I started kind of like a training program. I started a website called asktherealestateattorney.com. And I have on November 22nd, I'm going to do a $1,000 cash raffle to anyone who's like a member of the program. I know some people on here are already members, some are not. But if you go to the website, asktherealestateattorney.com, you can actually use the code LAW, LAW, to get like a free month of training. You can cancel anytime, and you will be eligible for the raffle on what was I going to say, on November 22nd, which we'll do live on Instagram. So I just want to make sure to tell you guys that before on that stuff. Okay. Okay. So closing costs, paragraph 9. So everything in this contract is negotiable. Okay. But 9A talks about the fees that are generally paid by seller. 9B talks about the fees that are paid by buyer. But as I said, everything is negotiable, but that's what each party generally pays. Okay. Now, on page 4, towards the top, it says check 1. So, and what this is basically who picks the title company, who pays for title insurance. Now, what industry standards are is in Dade and Broward, the buyer picks and pays. So they pick the title company, they pay for title insurance. Most of the rest of the state of Florida, the seller picks and pays. The seller pays for the title company, picks the title company, seller pays for title insurance. Okay, like for instance, so like in Palm Beach County, the seller would pick and pay. So for instance, the 3 options. The first option is seller shall designate closing agent and pay for owner's policy. So if you're submitting an offer in Palm Beach County, you checked off number 1, no one's going to question that because that's what's standard in Palm Beach County. Now, if you submitted an offer in, let's say, Fort Lauderdale, Broward County, you checked off number 1, 100% the listing agent is going to say, what are you doing? Because that's not what's standard. Like how this started like this with the in different counties, I have no idea, but that's kind of like what industry standards are. So in Broward and Dade, it's usually either number 2 or number 3. Number 2 and number 3 are basically the same thing where the buyer picks the title company, the buyer pays for title insurance. But the difference is who pays the search fees. Okay. So in Broward or Dade, if you're submitting an offer, I would say your best bet is to check off number 3, Miami-Dade Broward regional provision. Here, the buyer picks the title company, the buyer pays for title insurance, and the seller pays search fees. Okay. Search fees are probably about $450. Okay. So let's just say you submit an offer and you check off number 3, where buyer picks title company, buyer pays title insurance, and the seller pays search fees, and the seller makes a counter offer and checks off number 2. What that means is the buyer picks the title company, the buyer pays for title insurance, and the buyer pays search fees. So the difference between number 2 and number 3 is really about $450. So number 3 is definitely better for buyer, but if they make a counter offer and check off number 2, don't lose the deal over that, because that's really what you're talking about. So let's just go through again. We're slow. Number 1 is seller picks the title company, seller pays for title insurance, and seller pays search fees, which is generally, like I said, Palm Beach, I believe Naples, Orlando, pretty much everywhere but Broward and Dade County. Number 2, the buyer picks the title company, buyer pays for title insurance, and buyer pays their search fees. Number 3, buyer picks the title company, buyer pays the title insurance, and seller pays search fees. Okay. Now, why is it important to know industry standards? This happened more than once, but I'll use this as one example. We had a deal once, I remember. It was a property in Coral Springs. Broward County. And the buyer's agent was from Boca, and she submitted the offer. And full price offer, cash deal, they went under contract, we were doing the closing. And right before the closing, we send the closing statement to everyone to review. And the seller calls us, says, you know, why am I paying for the title insurance? Doesn't the buyer pay for that? And first, because the property was in Broward County, first I thought we made a mistake. So I pull the file, I look at the contract, and guess what? It was checked off. Line 168, number 1, seller should designate closing agent. So what happened is the agent from Boca, she was used to checking that because, you know, she's used to Palm Beach County. And truthfully, the buyer in Broward, the buyer's agent checked that off, but the listing agent, truthfully, probably just looked at the price, looked at the sale price, looked at the commission, and didn't worry about anything else, you know? And guess what? Now, even though it was a full price offer, everything went smooth. The seller finds out the day of closing, they're paying out about $2,000 extra in closing costs because the wrong box was checked. Okay. And I know you could say, well, the seller should have saw that too, but guess what? You're always going to be the one that got blamed. So guess what? Do you think that listing agent's ever going to get another referral from that seller? No way. Because who are they going to blame? They're going to blame the listing agent. And that's why it's so important. You know, you're dealing with so much money. Look at every box, look at every blank space, fill out everything. You know, and make sure everything's filled out correctly. You know, no matter how experienced you are, it can't hurt to have someone else look over the contract. You know, we all make mistakes, you know. And actually some of the biggest mistakes I've seen in my business were by really experienced realtors, honestly, missing things like, you know, where you would never think they would screw it up, and they did, you know. So, you know, same thing, if you're doing a contract, you ever need help on it, you know, you want someone to review it, just shoot it over to me. I could look over and answer this contract literally in minutes, you know. And of course, it's better to find out early if there's an issue than later on. So, you know, have that reviewed as soon as possible. You guys good so far? All right. The next thing I want to talk about, yeah, go ahead.
Giovanni, question. Can you use it as a negotiating tool? Like, in other words, that even though it's in Palm Beach County, normally where the seller pays it, but you are trying to get a better offer for it to go through, there's multiple offers
1,000%.
that the buyer.
1,000%.
Okay.
That's a great
That's what I've
negotiating
done.
tool. Even
Okay.
like when the market was going crazy, let's say in South Florida, checking off number 2 where the buyer says they're going to pay for everything. It's, even though it's only $450 difference, the seller may think, oh, the buyer's paying all these closing costs, and then accept your offer over somebody else's just for that little one thing by checking that box, you know? So yes, 1,000%, it's a strong negotiating tool. So yeah, definitely. If it's especially if it's multiple offers, things like that, I would definitely, you know, use that to your advantage. The next thing I want to talk about special assessments. Okay. Now, when people hear the word special assessments, the first thing they think about is associations. Okay. Just be aware that this paragraph has nothing to do with condos or HOAs. This deals with public bodies, city, county, state. Okay. What this is, for instance, like, let's say we had a hurricane and the city of Fort Lauderdale says, okay, for the next 3 years, we're going to charge every resident $100 a month to build a hurricane fund. That's what it would be. Okay. Truthfully, these are rare. And if there is any exist, they're usually part of the property taxes. And once again, these do have nothing to do with condos or HOAs. There's addendums for that. And like I said, I'm going to do a class on that next Thursday night. So, you know, if you guys want to attend for that. But here it gives you options, whether the seller pays the installments or the seller pays in full. Of course, as a buyer's agent, I would always check off seller pays in full, because you don't want to be the 1 in a million one where there is one. But just so you know, the contract does say, if the seller does agree to pay it in full, but they can't because it's part of, let's say, the property taxes where they can't pay it in full, then the buyer still has to assume it. So, but as a buyer's agent, I would still always check off seller shall pay in full. Okay. But once again, this has nothing to do with condos. This has nothing to do with HOAs, only public bodies, city, county, state. There's addendums for those other things. The next section, seller's disclosure. And this is really important because this is another thing that gets realtors in trouble a lot. Okay, so paragraph line 250, J, says seller knows of no facts materially affecting the value of real property which have not been readily observable and which have not been disclosed to the buyer. So what this is saying, that seller needs to disclose any material facts that affect the value of the property to the buyer. Okay, what is a material fact? A material fact is basically, if the buyer knew this, would they still pay the same price? If the buyer knew this, would they still offer the same amount? If the answer is no, then it's a material fact and you should disclose it. Now, what's important too is just to know that you, the realtor, have the same duty to disclose. There's actually a Florida statute that states this. Okay, so if your seller's ever telling you, don't disclose this, don't tell them this, and you know about it and it's a problem, you can be sued, you can get in trouble. So disclose. Okay, a lot of people ask me, well, what do I have to disclose? The way I look at it is, if it's bothering you, if you're asking, should I disclose this? If you're losing sleep over it, disclose it. It's always better to be safe than sorry, you know? And not only just disclose it in writing. You know, basically what, you know, for instance, like, let's say the garage was closed off without permits, and you told the buyer, hey, just want to let you know the garage is closed off without permits. And they're like, fine, I still want the house, right? Then basically, send them an email. Hey, this confirms I would let you know that the garage is closed off without permits. You still want the house. So this way, if let's say 3 years down the road, they're cited by the city because of the garage being closed off without permits, what's the first thing that buyer's going to do? You think that buyer's going to say, oh, no problem, I knew about it, I'll take care of it? No, they're going to say, oh, the seller didn't tell me, the realtor didn't tell me, I'm suing everybody. Then you can at least go in your file and say, no, look, on October 31st, 2023, we talked about this. Here's the email confirming our conversation. Okay. Once again, protect yourself, put everything in writing. Don't verbally, put it in writing. Another thing too, there's something called the seller's disclosure form where the seller fills out about what they know about the property. There's no state law that a seller has to fill one out. There's no realtor association law that the seller has to fill one out. But in my opinion, it's always good to get, not for the buyer, not for the seller. I think for you, the realtor, just in case your seller is lying to you. Like, for instance, let's just say one of the questions asks about roof condition. Let's just say your seller, there was leaks in their house and they're painting over the stains, and they fill out the seller's disclosure and they put you, the roof is perfect, right? Buyer does their inspection, their inspector misses the roof leak, and buyer closes. A week after closing, the roof collapses, which actually had to happen on one of my closings. What's that buyer going to do? They're going to sue the inspector, they're going to sue the listing agent, and they're going to sue the seller. They're going to say, everyone knew about this roof problem and nobody told me. So at least then you can go to your file and say, no, look, here's the seller's disclosure. The seller also lied to me. They told me the roof was perfect. So it's just something extra in your file to protect you in case your seller's lying to you. So as I said, I personally think it's good to get really to protect yourself. Hang on, I just want to see, I think there was a question. Yes, what she mentioned about keep on a venture bureau. Because here's like, there was something happened to her about on a property that there was actually a tax from the Bonaventure. So it does happen, but it's usually part of the tax bill. Before I go on, anybody any questions with seller's disclosure? Because that's really actually an important thing. Okay. All right.
Giovanni, what if you know that a seller is lying on a seller's disclosure? Like, I had checked to see if there was permits pulled because when the home inspection was done, he said that the sink was too close to the toilet. So when they did the renovations, it couldn't have been permitted, and I found out that it wasn't permitted. And what do you do in a situation like that? I had a horrific, ordeal with a realtor.
If you're the listing agent, first of all, and your seller's liar, you got to make sure you let them know they got to tell the truth, because if buyer finds out about it and turns out to be a major issue, they're going to get sued, and you're going to get sued for allowing them to do it. So first thing, as a listing agent, make sure they fill out the seller's disclosure. Don't fill it out for them ever, because guess what they're going to say? Oh no, I told the realtor there was problems with the roof. They wrote in there that the roof was perfect. They're going to blame you once again. But as a buyer's agent, well, first of all, a seller has no obligation to give you a seller's disclosure unless you put in the contract that it's required. Like, seller shall provide a completed seller's disclosure within 3 days or something. So if you don't put it in the contract, seller has no obligation to give you one. So if you do want one, you got to put it in the contract. Okay. Second, if you do get one as a seller, make sure, of course, your buyer reviews and then signs off on it. So this way later on, they're not saying, oh, I didn't know about this, But of course, if your buyer gets one, you still want to make sure they do their own inspection and make sure that, of course, they do everything during the inspection period. So if you're having doubts about what the seller's telling you, of course, cancel the contract. I mean, I don't know, if you're questioning it, but so, definitely,
right.
Go ahead.
No, we tried to cancel the contract. It was horrific. They kept the seller's deposit and everything, a portion of it. but I mean, they did so many things wrong. You know, we should really file an ethics complaint against the realtor. You know, my client didn't meet the mortgage contingency. But let me ask you a real quick question about the inspection period. We were trying to negotiate over certain issues. And so we gave the inspection period 7 days, but we're in the middle of trying to negotiate. And so then they said, oh, you're like pretty much, you know, shit out of luck. Your inspection period is over. So
Okay.
I should have did an addendum.
Okay, I'm gonna talk about inspections next.
Oh, okay.
Okay, so we go on to inspections. Any questions first before I go on? Okay. So this, hang on. Okay, so she had a question about the 40-year inspection where they were told it was already done, but it wasn't done. In one of the things added to the condo addendums is they're required to provide you this documentation. So once again, if they're verbally telling you, make sure you know you get the reports and everything from the association. I mean, from the seller, because they are required to, you know, in the condo addendum to provide this documentation. So, you know, make sure you get it. Make sure you try to get it as soon as possible, so your buyer doesn't go through the whole thing and then find out, you know, the building doesn't qualify or anything. But they are required to give it to you. Once again, as I said, it's in the addendums, which we will go over next Thursday. Okay, so inspection. So this is an as-is contract. So even though it's an as-is contract, the buyer has a right to inspect. Here it says 15 days, okay? So, first of all, I think 15 days is way too long, because this is why. With this contract here, it says on line 263, if buyer determines in buyer's sole discretion that the property is not acceptable to buyer, then buyer may terminate this contract by deliver written notice to seller. Okay, so the key word there is sole discretion. So buyer can cancel for any reason whatsoever. Okay, they don't even have to go in the house. They don't have to do an inspection. They can just say, you know what, I looked online, I don't like the schools there, I want to cancel. I drove by the house, I don't like the mailbox, I want to cancel. Any reason. Okay, like the FAR bar contract, they actually have to do an inspection with a professional inspector and to determine what can happen. Here, any reason. So I think 15 days is way too long. For one, as a listing agent, you don't want to give them 2 weeks and they cancel for something stupid. And as a buyer's agent, you know, you want to kind of lock in your buyer. You don't want them like talking to their friends. Oh, my sister's a realtor, she'll cut you back 50% of the commission or whatever, you know. So even if they want to get a professional inspector, 7 to 10 days is more than enough time, you know. So I think 15 days is too long. But regardless of how many days it is, you want to know how many. This is another thing that's not knowing the time period. So let's just say it is 15 days. Your buyer does their inspection. Now, 3 things are going to happen. They're either going to proceed, they're going to cancel, or they're going to negotiate. If they cancel, the cancellation is unilateral. Buyer telling the seller in writing that they're canceling cancels the contract. Okay. Now, to get the deposit back, you have to do what's called a releasing cancellation, where buyer and seller will both sign it, and then you get the deposit. But that could be done after. But during the inspection period, you want to make sure you send them the cancellation. Okay. Because if you do it after, your buyer's stuck. So now she had mentioned before that, I guess, correct from what you guys were negotiating something. Okay, so if you're negotiating, you have to make sure whatever you agree to is done during the inspection period, because once you pass the time period, so if you have 15 days to inspect, even though you're negotiating, you're talking to each other, you're sending emails, you're sending texts, and now it's day 18 and seller says, forget it, I'm not doing nothing, your buyer's stuck. So make sure whatever you agree to is put in writing, signed by both parties during the inspection period. Okay. So same thing, seller agrees to give you a $5,000 closing cost credit. It's day 15, 10 o'clock at night. You still don't have it in writing. Cancel the contract. You could always reinitiate the contract. Once again, texts, emails, verbal means nothing. Has to be in writing, signed by both parties. It's in the contract. We'll get that out later, or I'll show you where it says that. Because if not, it means nothing. You know, what I see some realtors do, they'll actually send like it attaches the proposed addendum, you know, giving us the $5,000 cross credit. If you agree, sign and send back. If you don't agree, also attaches the cancellation, where you're sending both together, so you're protected both ways. Correct. Carla just says, I was told that the as-is contract, the seller does not have to make any repairs. See, this is the difference between the as-is and the FAR bar. On the FAR bar, at the beginning, the seller agrees to be responsible for up to a certain amount of repairs or a percentage. Let's just say $5,000, right? The buyer has to do an inspection with a professional inspector. Now, if the repairs come back at $3,000, the buyer cannot cancel and the seller has to credit that money, okay? Now, if the repairs come back at $8,000, then either person can cancel because the repairs are more than what they agreed to. But they have to do a professional inspector and the report has to be given to the seller. Here, and the seller has no obligation to fix anything, okay? And just like the buyer can cancel for any reason, the seller's no obligation to fix anything. Of course, the ultimate goal is to close. And usually, of course, what happens, the parties negotiate and hopefully come to an agreement. Because now, guess what? Let's just say there is an issue about, let's just say, they find out the roof needs to be replaced, right? Well, guess what? Now, if the seller relists the property, they got to disclose that to the new buyer. So they're going to have to deal with the situation at some point. So, you might as well deal with it now. You can't just now pretend you didn't know about it and not tell nobody. So yeah, the seller is not required to fix anything because it is as is, but the ultimate goal is to close. Let me just think, anything else? What's that? Contrary. Any questions? Go ahead.
Giovanni, so the situation, they have put a claim on the deposit, the seller. The real estate agent now relists the property, never disclosing there were no permits or anything pulled for all the renovations. And the house was uninsurable because there was some issues that came up on the inspection report. I mean, wouldn't she be in violation then? And then they sold it for cash,
I was just gonna say, call the city. I mean, if they're not giving you your deposit back and you did nothing wrong,
Yeah.
I mean, but
Yeah, they sold it to somebody else for cash.
Yeah. No, I mean, technically they should have disclosed it because if they knew there was an issue and, they didn't disclose it. So yeah, and they still haven't given you your deposit back.
Well, they took like 4,000 of it. Yeah.
And then that's what happens. Like sometimes, these sellers like use that.
They did everything so unethically. It was ridiculous. But because, my client had to get an attorney to represent,
But that's what I mean. Like, that's what happens a lot. That seller knows that, it's going to be more expensive for the buyer to fight this. So they kind of squeeze money out of them. Really. All right. Okay. So I'll go on. All right. So on to page 6, line 280 says seller's assistance and cooperation in closing out of building permits. All right. So as a title company, our job is to give clear title to the buyer, right? We do searches with the city, the county, the state. We look for mortgages, code violations, IRS liens, judgments, anything that affects the value of the property, right? I mean, not affects title to the property. And of course, if anything comes up, we have to make sure it either gets taken care of before closing or at closing to give buyer clear title. Well, one thing that comes up a lot when we do searches is open permits. And what a lot of people realize, open permits do not affect title. There could be 10 open permits on the property and we can still give close, we can still give title insurance to the buyer, clear title, everything. And what this contract says, which is really interesting, it says that seller's not obligated to do anything. It even says the last sentence, line 287, says seller shall not be required to expend or become obligated to spend any money. Okay, so it's completely on the buyer. So as a buyer's agent, make sure if you're ever submitting an offer in the additional terms, put something like seller shall close out all open and expired permits prior to closing at seller's expense, like seller shall close out all open and expired permits prior to closing at seller's expense. So you're putting it on the seller, okay? Because if not, the buyer's responsible. An open permit could be something simple. It could be check the fire alarm, but it could be something major. Like we had one a couple of years ago. I remember it was some with the pool. They had to go through like 3 contractors to get it fixed. And so, once again, always of course, as a listing agent, if you get a contract where they didn't add anything to the additional terms about the permits, don't say nothing. But as a buyer's agent, make sure you add something in there because if not, protect your buyer.
Please repeat that clause again so we can write it down.
See if I could type it in. Seller shall close out all expired. Close out all. Oh wait, open and expired permits prior to closing at seller's expense. Okay, Yvonne asked if buyers getting financing in VA loan, seller still don't have to do repairs. Okay, same thing. There's actually a VA addendum, which once again we'll talk about next week, where in the VA addendum you would put how much the seller's responsible for. So you could put 0, and of course, if in the addendum it says 0, sellers don't have to make any repairs. If you put, let's say, 2,000, that seller would have to be responsible for up to 2,000. So it would be whatever's agreed to in the VA addendum. Which of course, if it's an FHA loan or VA loan, you do have to use this VA addendum. Okay. Okay, you guys good so far? All right. Okay. Escrow agent. Actually, just because we're just talking about deposits, just so you guys are aware, let's just say buyer wants to cancel the contract, right? To get the money back, we have to do what's called a release and cancellation with both buyer and seller sign, say who's getting the money. Okay. Now, let's just say the buyer canceled during the inspection period. And even though I'm 1000% sure the buyer gets the money, I can't release the money unless the seller signs something. And seller sometimes refuses to sign. Okay. And so if you ever have that situation where, let's say you're asking the title company to release the money and they say they can't unless something's signed, don't get mad at them, because truthfully by law, they can't release it unless both parties sign. And then what happens if you can't get both parties signed, the next step is you have to basically file a lawsuit, what's called an interpleader action, where you sue the buyer, you sue the seller, and you tell the judge, Your Honor, we were holding $10,000. They can't figure out who gets what, you make the decision. Okay. Here's the problem with that. Even though I'm an attorney, if I'm the one holding the money, I can't represent myself. I actually have to hire an attorney to do this for me. So guess what happens? I hire this lawyer, and this lawyer usually charges about $2,500 and about $500 in court costs. So he files the interpleader action. He sues the buyer and seller. The first thing he's going to do is going to file a motion with the court. He's going to say, Your Honor, we filed this motion for interpleader. Can we get our $3,000 out of the money in escrow? Guess what that judge is going to do? Immediately give them that money. So let's say it was $5,000 in escrow, and now they're fighting over $2,000. All right, and now the buyer has to get an attorney, seller has to get an attorney. It could go on 2 years. So truthfully, it's always best to try to work it out, because there's really that's what's going to happen. Of course, it's 50,000 escrow, 20,000 escrow. It's a different story. But when it's a little bit amount, the only person making the money is going to be the attorneys. And as I said, some sellers know this and use it as a way to kind of squeeze some money out of the buyer. Buyer's default. I mentioned before about deposits. Okay. Now, in the listing agreement, there's usually a provision which states that if of course, the realtor brings a contract and the buyer defaults, meaning the buyer cancels for no valid reason, not because of inspection, not because of loan approval, just basically the day of closing says, I don't want the house, right? Then it says that usually the listing agreement says that the listing agent would get, like, let's say 50% of that deposit. Okay. And what's important to know here, it also states here, it says the portion of the deposit, if any, paid the listing broker upon default by buyer shall be split equally between listing broker and cooperating broker. So that means if the listing agent's getting some money, the buyer's agent gets some money. And I've had this happen actually twice in probably the last 3 months, where we got a release and cancellation sign where it actually had money going to the seller and money going to the listing agent. And both times, like, I saw it and I said to the buyer's agent, because usually I'm getting the work from the buyer's agent, said, hey, do you know you're entitled to money here? And they had no idea. So like one was like $20,000 and they had 10,000 going to the listing agent and 10,000 going to the seller. And the realtor didn't know she was entitled to $5,000. So once they, I told this and showed it to them, basically they read the release where buyer's agent got 5,000, seller's agent got 5,000, the seller got 10. So if the listing agent's making a claim on some of that deposit, the buyer's agent's entitled to money too. And, and this is important to know, well, if the listing agent's not making any request for the money, then the buyer's agent can't do nothing. But if the listing agent's getting money, the buyer's agent's entitled to money. And actually, if your buyer defaulted, they're probably not going to buy anything anyway. So if you have that situation, maybe even bring it up to the listing agent and say, hey, we could be entitled to money, because some listing agents aren't even aware of this. So it is, you did the work, you should get, why shouldn't you get paid? Any questions with that? Okay. All right, we're almost done. Okay, page 8 towards the bottom where it says time. Okay, this is the section where I talked about the Saturdays, Sundays, legal holidays, the calendar days, the midnight, just so you know where it's at in case you're ever arguing with another, realtor or something about the time periods, you know where to look. Page 10, line 535, integration and modification. You see the last sentence of this? It says no modification to or change in this contract shall be valid or binding upon buyer or seller unless in writing and executed by the parties intended to be bound. So once again, no texts, no emails, no verbal, has to be in writing, signed by the parties to, be valid. Okay. FIRPTA, talk about that real quick. Okay. FIRPTA is basically when you're dealing with a foreign national seller. Basically, the title company is supposed to hold back 10 to 15%. We're gonna actually do a class on FIRPTA I forgot what date, but I know in one day in November. And I'm actually gonna try to get a CPA on with me to speak, to answer any questions you have. So FERPTA is when we're holding back, we have to hold back 10 to 15%, but depending on the situation. So let's just say it's a $400,000 sale. We're supposed to hold back, let's say $40,000. What the purpose of it is, like example, let's say the seller's from Brazil. They're worried that the person's going to sell their house, go back to Brazil and not pay taxes. So the IRS wants us to hold money. So what happens is seller would be forced to file their taxes. But now let's just say they do their taxes and they owe $5,000 to the IRS. Then IRS would get 5,000 if seller gets that other 35,000 back. It's not like the IRS gets all the money. They just force them to do their taxes, basically. Now there is an exception. If the sale price is under 300,000 and buyer's going to live in the property, then you don't have to hold back any money. Okay. So if you're ever selling a property and the seller's a foreign national and the sale price is under 300, try to find a buyer that's going to live in the property. So this way you don't have to deal with the FERPTA issue. Okay. As I said, I think she's posted November 30th. We're doing a class on FERPTA. And like I said, I'm gonna have a CPA on the class as well. So we'll answer any questions you guys have. Okay. I think you guys all saw this on line 621. This deals with the foreign buyers and stuff. Where, you know, buyers from certain areas are not supposed to be able to buy. Truthfully, this provision is really confusing. I think it's confusing for everyone, honestly. No one truly understands it. But what we're required to do now, we're required to have all buyers sign an affidavit that this doesn't apply to them. So on every closing, like we do personally, when we send out like the buyer's seller information sheets, we send this to the buyer and have them sign it. And technically, I guess as long as they sign it, we're kind of relieved the liability. But it is definitely very confusing. I don't think anybody really understands. They're probably gonna have to like really amend it to make it more clear. But we do that. On every closing, we personally do. And I'm sure every title company's doing that. We do have buyers sign an affidavit that this does not apply to them. Hang on a second. Just reading the chat. Well, yeah, what you just said, Ruth. Ruth said just closing a vacant lot in Cape Coral and the title company held back 15% as the seller was a foreign national. Title company said the $300,000 under rule did not apply to vacant land. Exactly, because the buyer can't live there until the house is done. It would have to be like they have to be able to, like, you know, immediately move in. So if the house has to be built still, it would apply. Okay, so the last thing we'll talk about here is actually, let me go back real quick. So page 11 towards the bottom is all the addendums. As I said, I'm gonna do a class next Thursday night at 6 on all the addendums, and you know, so we'll go through that. And then the last thing we'll talk about here, line 643. So basically, let's just say the MLS says that they're paying buyer's agent 2%. And you contact the seller and say, listen, I have a full price offer, but I want 3%. Will you pay me 3%? And the seller says, yeah, we'll pay you 3%. And you over here, you put in the additional terms. You know, your name, your broker, 3% each, right? And you go to closing. How much do you think you're getting paid? You're getting paid 2%. Whatever's in the MLS controls. It says right here, line 643. This contract shall not modify any MLS or other offer of compensation made by seller listing broker to cooperating broker. So the MLS is what controls your commission. So for instance, first of all, any offer you submit, print the MLS to make sure somebody doesn't change what they're offering you. Second, if you're negotiating something, make sure either one, they change it on the MLS, or two, get a letter from the listing broker authorizing the change, not from the listing agent, from the broker. Because the listing belongs to the broker, not the agent. Only the broker can change it, okay? So one, either make him change it on the MLS and force print it, or get a letter from the broker, because believe it or not, a lot of realtors know this and use it to their advantage. I've seen it many times where the listing agent will tell the buyer, yeah, don't worry, we'll pay you 3%. And then the day of closing, they'll tell us, no, look at the MLS. MLS is 2%, because they know what's the buyer's agent going to do now. It's the day of closing. They're not going to, you know, postpone the closing because of this, and the contract specifically says it. The MLS is what controls. So look out for that, because like I said, I've seen a lot of listing agents, which is sad, you know, be untruthful and lie to the buyer's agent what they're going to pay them. Let me see a question. Okay, any questions? Any other questions?
Yeah, I got a question about escrow.
Sure.
If the broker is actually holding escrow, I know it's a little different guidelines and things like that than if you're holding escrow.
Yeah.
But if I'm holding escrow and the person doesn't get approved, and I know for a fact they didn't get approved within the specific amount of time, and we send a release in cancellation, I have the liberty to return that escrow, correct?
Well, okay, when a real estate company is holding the money, you're supposed to, comply with FREC rules. Because that's who basically controls any escrow disputes when the real estate companies, and that's of course why a lot of real estate companies don't want to hold escrow because they don't want to deal with that. So the truth is, I think it's risky if you just release the money, because if you get, because there's a good chance the seller's going to, because in your view that you feel that the buyer's 100% right, but for some reason the seller might have it in their head that they think they're 100% right, and not only, and then end up suing you. Like I've actually had that happen where we've gotten sued, and I had to pay a few $1,000s just to get out of the stupid thing. And really why they sued me was for no real valid reason. So people will sue you for anything. So I think it's just better to be safe and just get something signed by both parties and don't put yourself at risk, because here, especially here, the deal died. You're giving money back. You're not making a penny, and now you're being sued and have to spend $5,000 on an attorney. So I would recommend definitely getting it signed. Even though you feel that the other person's completely in the right, I would get it signed. So we'll try to pull that. Any other questions? Just real quick, but if you guys think of any questions. So Thursday.
Giovanni, I was
Yeah.
talking about the trying to change the listing, the compensation just
Mhm.
before closing. I had somebody do that, and
Yeah.
they didn't get away with it though, because I had the listing printed from the time we made the offer with the compensation.
Yeah, I mean, it's hard to believe, but there's actually a lot of unethical agents in South Florida. I mean, it's really hard, but yeah, definitely always print the MLS sheet when you submit an offer, especially if they're offering a bonus or something like that. Those magically disappear a lot, so definitely print it. And once again, if they change it, print it. Just a couple, I guess, housekeeping things. So Thursday we're gonna do a class on the new condo laws. I've actually the attorney from our underwriter going to be speaking with me on that. So it's on all the new condo laws. That's Thursday. Saturday, I'm doing a class marketing on a $100 a month budget. So basically giving you some tips of things, from speaking to other agents, seeing what other agents do. Because people always think you have to spend a lot of money to get leads. You don't. There's so many things you could do out there to get business. So I'm going to do a class on that Saturday. What else? But we have a lot of stuff lined up for November. I think we're doing a chat GPT class. For the short sales, all kinds of stuff. So definitely, and once again, like I said, the website's asktherealestateattorney.com, asktherealestateattorney.com. To join the program, use code LAW, so that it's free for the first month's training. You can cancel anytime, and everybody who is a member. So the people on here are already members. You will be eligible for the $1,000 cash raffle on November 22nd. Any questions? Ruth asked on Thursday. We're doing it at 11 o'clock, Saturday 10:30, and you guys will you'll definitely get the information. But you guys have any questions about anything? It doesn't have to be about this, about any deals you're working on, anything I could help you with. Just, I'm here right now. Ask away if you want. No? All right, so we'll log off. All right, but thank you guys for participating. I really appreciate it. And if you do have any questions, need any help, feel free to reach out anytime. I'm always there to help, okay? Thank you. Thank you, Catherine. All right?
Thank you, Giovanni.
Okay, have a great day, everybody. Thanks.
Thank you. Have a good day. Bye-bye.
Okay, bye-bye, everybody. Thanks.